Welcome to the Bracewell webinar on paid leave. I am Leslie Selig Byrd, and Amber Dodds and I will be the presenters today. A few housekeeping matters first. We want to remind you that the webinar has been approved for CLE. Also, if you have any questions, please submit those during the presentation. We'll answer the questions at the conclusion of the presentation, or if time is limited, we'll be sure to follow up with a response to you by email. Amber and I have substantial experience in advising and defending employers in leave issues affected primarily by federal laws. The reasonable accommodation and confidentiality provisions of the ADA, and for federal contractors, Section 503 of the Rehabilitation Act, pregnancy leave under Title VII, and the complexities and protections under the FMLA. More recently, Amber and I have assisted our clients in designing and implementing paid leave policies compliant with state and local laws. Never before have state and local laws so significantly impacted the employment law landscape as they do today. Yesterday, Amy Halevi and Becky Baker spoke on the way in which sexual harassment and discrimination laws are dramatically changing at the state and local level in the wake of the Me Too movement. Tomorrow, our partner Bob Nichols will present on the intersection between state laws regulating drug testing and the rapidly developing laws on marijuana use. Today, Amber and I will review the various types of leave legislation and offer our insights and recommendations for those affected by the rapid evolution of state and local paid leave laws. San Antonio Mayor Ron Nirenberg recently voiced his public support for the San Antonio Sick and Safe Leave Ordinance, stating, "Our goal is to bolster public health and quality of life for all of our city's residents and to provide all San Antonio working families a better chance to remain healthy on the job and safe at home." This sentiment is not unique to the City of San Antonio public officials. Similar statements are made by state and local officials nationwide. Yet the resulting proliferation of state and local paid leave laws has contributed to great confusion, frustration, and significant challenges. While these laws and ordinances have some common denominators, the differing and potentially conflicting requirement in these laws presents significant administrative and compliance challenges even for our single location clients. You can just imagine the burdens upon our multi-jurisdiction clients. First, so that Amber and I do not contribute to the confusion, let's begin by defining the two different types of leave we will be discussing. We will refer to earned paid time for sick or safe reasons, typically ranging between 40 to 64 hours per year, as paid sick leave. Paid sick leave is a benefit provided by the employer. While each paid sick leave law is unique, today when we refer to sick leave, we include the employee's physical or mental illness or injury, including preventative care, as well as the employee's need to care for his or her family for these reasons. And family, by the way, is broadly and inconsistently defined depending upon the jurisdiction. Now, when we refer to safe leave, we include the employee's or family's need to seek medical attention, relocation or other services, or to participate in a legal proceeding relating to domestic abuse, sexual assault, or stalking. During the presentation, we will refer to pay for extended absences for employee medical or family reasons, ranging between, say, 4 to 6 to 26 weeks, more or less, depending upon the jurisdiction, as extended paid leave. Extended paid leave may be funded by contributions from the employee only, from the employee and employer, or in limited instances from the employer only. Legislation passes daily, but at this very moment, we have a total of 35 states, counties, and municipalities with short-term paid sick leaves. 11 states have paid sick leave: Arizona, California, Connecticut, Maryland, Massachusetts, Michigan, New Jersey, Oregon, Rhode Island, Vermont, Washington, and the District of Columbia also has a paid sick leave. This year, Maine and Nevada added yet another type of paid leave to the mix. Maine and Nevada were the first states to pass a short-term paid sick leave law that did not limit usage to sick or safe-related reasons. Employers are required to provide accrued paid time off that can be used for any purpose up to the cap. Now add 5 counties: San Francisco, California, Cook County, Illinois, Montgomery County, Maryland, Westchester County, New York, and soon to follow Bernalillo, New Mexico. Add 18 cities: Berkeley, Emeryville, Long Beach, Los Angeles, Oakland, San Diego, San Francisco, Santa Monica, all in California, Chicago, Illinois, Duluth, Minneapolis, and St. Paul, Minnesota, New York City, New York, Philadelphia and Pittsburgh, Pennsylvania, SeaTac, Seattle, and Tacoma, Washington. And this total of 18 does not include Austin, San Antonio, and Dallas. That's another story we'll discuss later in the presentation. Now let's distinguish the second type of leave. 8 states: California, Connecticut, Massachusetts, New Jersey, New York, Oregon, Rhode Island, Washington, and the District of Columbia has established programs for extended paid leave. Before we provide guidance on navigating through these state and local laws, you may be asking, how did we get here? Amber has significant experience and knowledge on this topic.
Thank you, Leslie. Federal law, as many of you know, under the Family and Medical Leave Act, provides for up to 12 weeks of unpaid leave for eligible employees for many reasons, such as the employee's own serious health condition, to care for a qualifying family member with a serious health condition, for the birth, adoption, or placement in foster care of a child, for military exigencies, and to care for an injured or ill covered service member. The FMLA provides extended leave for many employees, but studies demonstrate that more than 40% of employees are not eligible for FMLA leave, either because they do not meet the eligibility requirements, or because their employer is not covered, or because they do not work at a location which covers FMLA leave for employees. For those individuals, they are dependent on their employer for policy-based extended leave, or dependent on leave as a reasonable accommodation under the Americans with Disabilities Act for their own disabling condition. Also, even those employees covered by the FMLA are not guaranteed pay during their leave, only job-protected leave. While no federal law requires extended paid leave, lawmakers have agreed that paid family and parental leave is valuable. Yet, even more than 25 years following the enactment of the FMLA, no agreement has been reached on how to pay for extended paid leave. That is not for lack of proposed legislation to provide extended paid leave. Let's look at some examples. Senators Marco Rubio and Mitt Romney have proposed the New Parents Act, which would provide up to 3 months of paid leave in exchange for a 3 to 6 month delay in retirement age for Social Security purposes, or a reduction in the payments under the first several years of Social Security payments. Senators Gillibrand and Representative DeLauro have proposed the Family Act, which would provide up to 12 weeks at 66% of employees' monthly wages, paid for by a 2% payroll tax on both employees and employers. Yet another option, Senators Ernst and Lee have proposed the Cradle Act, which would provide up to 3 months of paid leave while delaying retirement benefits by 2, 4, or 6 months. Again, we are seeing significant proliferation in state and local regulation of paid leave because of the absence of federal legislation providing for such paid leave. How many employees really do not have access to paid leave? The Bureau of Labor Statistics within the Department of Labor recently issued a press release regarding the availability of paid leave in 2018. As of March 2018, 71% of workers had access to some paid sick leave, but only 31% of the lowest paid 10% of workers were eligible for paid sick leave from their employer, while 92% of the highest 10% of paid workers had paid sick leave. Similarly, 77% of all workers had paid vacation, while 41% of the lowest paid 10% of workers had access to paid vacation from their employer. And again, 92% of the highest paid 10% of workers had vacation. As you can see, there is a disproportionate need for paid leave among the lowest wage earners. Let's transition now to how provision of vacation, sick time, and paid time off by policy meets current legal requirements. For those employers that provide paid sick leave benefits, it can be easy to assume that they are already complying with state laws and local ordinances. Leslie and I frequently hear something like this: my company provides more paid time off than required by this ordinance, so we must be compliant. While, of course, provision of sufficient paid time is critical to complying with ordinance requirements, that is only one element of compliance. I want to raise quickly here another type of state law that Leslie and I have not yet mentioned, which laws are generally referred to as kin care laws. These types of laws do not require employers to provide paid sick leave, but they do mandate that if such leave is provided, employees must be allowed to use it to care for illness or medical appointments for covered family members. Georgia and Illinois are examples of states with kin care laws. Most clients that we see do not restrict paid sick leave to use by employees for their own condition, but this is a good reminder that kin care laws exist at the state level. So let's begin. Even the most generous paid time off policies can run afoul of ordinance requirements for carryover and payout of leave. Another aspect of carryover and payout is that unlike accrual or usage requirements, carryover and payout differ significantly between ordinances and laws. Let's look at some examples. Arizona's Fair Wages and Healthy Families Act provides that employees may carry over earned paid sick leave up to certain ordinance caps, which are set based on employer size. Alternatively, the state law allows employers to choose to pay out accrued leave in lieu of carryover. so long as they provide all of an employee's annual leave at the beginning of the benefit year. In other words, employers may choose not to allow carryover, but they have to front-load paid leave in the next benefit year so that the employee has paid sick leave available at the beginning of the benefit year should it be needed right away. The New Jersey Paid Sick Leave Act makes it much more complicated, requiring carryover but allowing employers to provide employees with an option to either be paid for all or half of their unused paid sick leave in the last month of the benefit year, with the other half being carried over. New Jersey employers that front-load all available paid sick time must either pay out the prior year's unused paid sick leave or carry it over. As another example, the Embryville, California minimum wage and paid sick leave ordinance requires carryover, subject to accrual caps, with no option for payout or forfeiture with front-loading. As yet another and different example, the Rhode Island Healthy and Safe Families and Workplaces Act allows employers to choose whether to allow carryover of paid sick leave or require forfeiture. Leslie, what are some other common elements of paid sick leave ordinances?
Yet another element and potential compliance challenge is the various requirements on record keeping. For example, San Antonio, not yet implemented, 3 years similar to the FLSA, Fair Labor Standards Act. Arizona, 4 years of record keeping of paid sick leave accrual and usage, and those records must be provided to employees upon a reasonable request. California, 3 years. Similar to the FLSA, an employer's failure to maintain records under these laws has unfortunate consequences. In Arizona, for example, an employer's failure to maintain records creates a rebuttable presumption that the employer violated the law. And in California, when the employer fails to maintain records, the employee is presumptively entitled to the full amount of accruable leave unless the employer has clear and convincing evidence to the contrary. Clear and convincing is a very difficult burden. These are common provisions in most of the laws. Employers should also pay attention to the diverse requirements on what is sufficient notice to employees of rights, their rights under the laws, and where the notice should be posted and how it should be distributed. Most of the laws and ordinances impose notice requirements of the policy to be included in any existing handbook and also require any poster provided by the state or local department charged with the enforcement of the laws to be posted in a conspicuous place. We've reviewed some of these postings, and you will not be surprised that they give very, very specific instructions to employees on how to file a complaint, the name of the agency, the address, the contact, the telephone number of the contact, the email of the contact, all very, very specific. In the San Antonio, Texas ordinance, for example, any handbook must provide notice of an employee's rights and remedies, specifically somewhat similar to the notice in the various policies about notice of rights. The issue is how close does it need to be? That's an unanswered question. Do you need to actually include the name, the address, the contact number of the enforcement agency in your handbook? New York City requires employers to record the date the city required notice of rights was provided to the employee, and in addition, the employers must retain proof of receipt. Chicago, in addition to the city's poster, employers must provide employees written notice of rights under law in the employee's first paycheck. Signage posters are typically dependent upon whether it is provided by the enforcement agency. If provided, an employer must display the notice in the dozen or more listed language if spoken by a certain percentage of employees. For example, in California, Emeryville, if spoken by at least 10% of the employees, Los Angeles, 5% of the employees, DC, if 3% of the employees speak the particular language, the poster needs to include that language. Now we'll proceed to discussing additional compliance traps that employers should be wary of. Preliminarily, we go to who is covered. Now, continuing with our consistent theme today, the laws vary in determining employer coverage, who is an employer under the particular law, and who is an employee eligible for benefits. What is a common thread is that, not surprisingly, city, state, and federal employers are exempted from coverage. The following states and cities provide a summary of these variations. For example, Arizona. Any employee is covered except immediate family, and any employer except, of course, as I mentioned, federal and state and local employees. California. Any employee who has worked at least 30 days per year for the same employer, regardless of whether the employee is full-time, part-time, temporary, a seasonal employee. And any employer is covered if the employer employs at least one employee. The cities of California vary. Berkeley, Emeryville, Los Angeles, Oakland, San Diego, Santa Monica define an eligible or covered employee as one who performs work at least 2 hours in a week within the particular city and including commuting from a home in the city. 2 hours in a week. You can imagine the record-keeping nightmare. San Francisco defines an eligible employee as one who performs at least 56 hours of work per calendar year in San Francisco. Texas is more consistent. Austin, Dallas, San Antonio. An eligible employee in any of these cities is an individual who performs at least 80 hours of work within the city, and I am emphasizing within the city. It's important in all of these laws that the hours of work be documented in the particular city as opposed to out-of-town work in order to determine eligibility. Again, another record-keeping nightmare. In Texas, Austin, Dallas, San Antonio, similar to the other laws, it does include work through a temporary or employment agency. And we have quite a few employers who do have individuals who work for them through a temporary or employment agency. The statute excludes specifically independent contractors and unpaid interns. The employer is broadly defined in all 3 cities and only excludes, yes, federal, local, and state employers. Philadelphia, Pennsylvania, all full-time, part-time, and temporary employees who work at least 40 hours in Philadelphia within a calendar year, excepting independent contractors and seasonal workers. Employers are entities that employ 10 or more workers. In Pittsburgh, a covered employer is one that employs 1 or more workers in the city. As a reminder, in acquisitions in jurisdictions with paid sick leave law, when your team is performing due diligence, be aware that a successor, and that term is defined by law, is obligated to provide the predecessor's employees hired by the successor with any accrued and unused sick leave when the acquisition took place.
Some additional compliance traps. First, which absences are covered? I want to emphasize here an issue that Leslie raised earlier, which is that while we generally think of paid sick leave as for the employee or his or her family member's medical appointments or illness, many of these ordinances expressly cover other types of absences, including time needed when the employee or a family member has experienced domestic violence, sexual assault, or stalking, for example, to obtain medical treatment, legal assistance, or a safe residence. Another type of absence covered is when an employee's workplace or the school or daycare of an employee's child is closed for public health or safety reasons. Finally, the Rhode Island ordinance even covers absences due to caring for the employee or a family member who health authorities have determined may jeopardize the health of others with that person's presence. The emphasis here is to remember to review the specific boundaries of the applicable law or ordinance before assuming that an absence is or is not covered by paid sick leave. Remember, too, that while there is substantial overlap, the laws and ordinances define who is a covered family member differently. It is important to confirm the language of the applicable law or ordinance as to who is a covered family member. Covered family members under these laws and ordinances extend well beyond those covered by, for example, the FMLA, and include children, parents, spouses, in-laws, grandparents and grandchildren, domestic partners, siblings, or members of the employee's household. Another compliance trap can be ensuring that employees are receiving sufficient notice of their available paid sick leave as required by the ordinance. For example, the Dallas, Texas ordinance requires that employees, quote, shall be provided electronically or in writing information showing the amount of the employee's available earned paid sick time. The ordinance does not address whether a general statement of available PTO may be sufficient, whether this notice must be included with the employee's pay statement, or whether access to an electronic system to which the employee can log in is sufficient. To give you a flavor of the technicalities of this notice, let me read quickly from the Dallas frequently asked questions. First, sufficient notice differs based on the method by which the employer calculates available leave. Under the accrual method, employers shall provide a statement with the name of the employee, the name of the employer, a date, the statement period, the number of hours worked within the geographic boundaries of the city during that statement period, the amount of time accrued, the amount of time used, and the amount of available time left in the bank. Under the front-loading method, a little bit easier. The statement shall include the name of the employee, name of the employer, date, statement period, paid sick time hours made available at the beginning of the year, the amount of paid sick time used, and the amount of available paid sick time. So again, each ordinance and law differs regarding employee-specific notice of available time. Another compliance trap. Does a collective bargaining agreement affect the application of the ordinance's requirements? Again, here, laws and ordinances handle CBAs in different ways. For example, the California Healthy Workplaces, Healthy Families Act exempts employees from coverage altogether if those employees are covered by a valid collective bargaining agreement that provides paid sick leave and other benefits. But wait, if those employees are in Los Angeles, the ordinance there prohibits waiver of its requirements even by a collective bargaining agreement. So here are several compliance traps to be aware of. What Leslie and I also hear is, how can I address potential abuse of leave by employees? Leslie, can you give us some thoughts?
Sure. Under various laws, and I'm going to give you a candid heads up, employers will be frustrated with the limited means to lawfully address potential abuse in the use of leave. Yes, there are some limited protections for employers and even more limited obligations on the employee. For example, Austin, employers may ask for reasonable verification of the reason for leave of more than 3 consecutive days. Dallas and San Antonio is the same, but they add that the employer cannot require details about the nature of the condition or situation requiring leave. And I note that even though Austin did not mention this, that it is consistent among the ordinances that employers cannot require details about the nature of the condition or situation requiring leave. Austin and San Antonio, employers are required to make a timely request before their scheduled work time, except for unforeseeable reasons. The Dallas ordinance is silent on this issue. Philadelphia, the employee shall provide advance notice for foreseeable leave, but goes on to state that the employer shall provide leave on the written or oral request of an employee, and states nothing further. Employers may require reasonable documentation that sick time was used for a permitted purpose for absence of more than 2 consecutive days, but again cannot inquire about the nature of the illness. Pittsburgh, employees again shall make an oral request for sick time at least 1 hour before the work shift, if foreseeable, unless the employer has a reasonable notification policy, but apparently no greater than 7 days before scheduled leave. How do the laws address an employer's right to identify and react to a pattern of misuse of sick and safe leave? The state of California is silent, as are many jurisdictions. San Antonio is one of the rare cities who actually provide guidance on this issue. The FAQs issued by the City of San Antonio Metropolitan Health District provide the following guidance on the employer's discretion. Employers suspecting abuse of sick and safe leave, including patterns of abuse, may request verification of the employee's need for leave consistent with state and federal laws. Indications of pattern of use may include, but not be limited to, repeated use of unscheduled sick time adjacent to weekends, adjacent to holidays, adjacent to vacation, adjacent to payday, and on days when leave has been denied or when mandatory shifts are scheduled. An employer must abide by all existing laws regarding discrimination in any of these requests. Several of the questions that we understandably receive from clients are, what are the consequences of enforcement? What are the consequences of non-compliance? What are the consequences of a civil lawsuit, an administrative lawsuit, And what are the remedies available to employees? Employees must make a timely claim. Timely may mean 6 months to 3 years from the date of violation, depending upon the jurisdiction. Michigan, Pittsburgh, 6 months from violation. San Antonio, 1 year. Dallas and Austin, 2 years. Duluth, Minnesota, 1 year. Arizona, 2 years, or 3 if willful. Again, similar to the FLSA. The state, city, or county will conduct an investigation of an employee complaint. Be aware that these employee agencies have the power to subpoena witness testimony and records. These agencies encourage prompt voluntary compliance and give benefits to the employer for that compliance. Absent resolution, enforcement may be by the employee or by the public agency in an administrative proceeding or court. Some ordinances do not permit a civil action. For example, Michigan, Illinois, Massachusetts, Oregon, Arizona, Berkeley, Emeryville, Philadelphia, Pittsburgh, all permit an administrative or civil action. Long Beach, California, uniquely permits class action in civil court. Retaliation is consistently prohibited in various laws, yet still important nuances. California, a rebuttable presumption of retaliation if the adverse employment action occurs within 30 days of protected activity. Emeryville, California, if within 21 days. Philadelphia, Pennsylvania, D.C., if within 90 days. And all of these statutes typically say, unless the employer has clear and convincing evidence, again, that very difficult burden of just cause for the adverse action. Notably, the Dallas FAQs clarify what we know is that discipline of an employee who misuses their earned paid sick time hours is not unlawful retaliation. Penalties, they're unique to each law. California, $250 penalty, 3 times the amount of sick days, maximum penalty of $4,000. Emeryville, California, $1,000 for each employee retaliated against, $500 for failure to provide notice of the right to designate a person in lieu of a spouse or domestic partner. That's a very unique provision. The city or employees may pursue administrative remedies, file an action for injunctive relief, damages, civil penalties, and reinstatement. D.C., willful violations, $1,000 to $2,000. Chicago, civil action, treble damages. Maryland County, damages. Massachusetts has higher penalties, $7,500 for the first violation, $1,500 for the first intentional violation, $25,000 for any later violation. Employees may recover treble damages if they bring a civil action. Now, I've mentioned a couple of times that the nation is watching as the Texas presents a challenge to the local ordinances. Everyone is interested in Texas's reaction to the 3 ordinances that have been enacted by the various cities. Certainly, Texas has been a focal point of the nation's paid sick leave growth since last year. During that time, Texas has seen 3 cities pass paid sick leave ordinance, as I mentioned, Dallas, San Antonio, Austin, and all resulted in 3 lawsuits. The Austin ordinance was temporarily enjoined, and the lawsuit by the business groups is pending before the Texas Supreme Court, awaiting a decision on whether the highest state court will review the decision of the Court of Appeals. What did the Court of Appeals hold? It held that the Texas Minimum Wage Act preempts local regulations that establish a wage that the Austin Ordinance establishes a wage, and that therefore the Austin Ordinance is unconstitutional. Briefing is due early 2020, and the Supreme Court decision on whether to review the Court of Appeals decision is not expected before the summer of 2020. The Dallas Ordinance is challenged in the Eastern District of Texas Federal Court on similar grounds as the Austin Ordinance, yet a distinction. The Dallas Ordinance, unlike the Austin Ordinance, went into effect August 1, 2019. The San Antonio Ordinance is a mix. The ordinance was challenged in Bexar County District Court, and a tentative settlement was reached, delaying the implementation until December 1, 2019. The specially appointed Sick Paid Leave Commission sought revisions to the argument to address the argument that the Texas Minimum Wage Act preempts local laws seeking to regulate wages in private employment. The issue in these challenges is whether the ordinance establishes a wage. So the revisions to the San Antonio Ordinance seek to avoid legal challenges by, you're not going to be surprised, describing the sick leave pay as a sick leave benefit. Now, opponents are doubtful that a simple change from emphasis on benefit rather than pay will overcome legal challenge that the ordinances are unconstitutional. Business groups have reserved the right to seek another injunction and reinstate legal challenge, and if so, have said they will do so by November 7, 2019. Soon, in view of the Texas Supreme Court's timetable on the review of the similar Austin Ordinance, the Supreme Court will not issue a definitive decision before the effective date of December 1, 2019, as was initially hoped. Now to the second type of leave we introduced. The extended leave laws in the 8 states and D.C. provide their own unique set of conflicting provisions, particularly for our multi-jurisdictional clients. Amber will highlight these differences now, as well as the challenging interaction of these extended leave benefits with other paid leave.
Thank you. Leslie and I provide this slide as a brief introduction to each of these states' programs. I promise I won't go through each of them here. We want to emphasize how different each state's program is from other states. I include next to each state name the first year in which the program was effective, as determined by when benefits would begin to be paid. The most recent states to enact programs have begun collection of premiums a full year or more before benefits will be paid. While many states have expanded or revised their programs since implementation, the first effective date, as set out on the slide, gives you a sense of the momentum these types of state programs are gaining. Most of these state programs cover all or nearly all private employers within the state. Employee eligibility is based on the number of weeks worked or amount paid to the employee, or both, over a base period. Programs in California, Rhode Island, and Connecticut are funded by employee-only wage deductions. Programs in New Jersey, New York, Washington, Massachusetts, and Oregon are funded jointly by employee and employer payroll contributions. Finally, the District of Columbia requires employers to fund the program based on a percentage of all wages paid to employees. Regarding benefit amounts, there is wide variance between the programs. Some are based on a percentage of the employee's wages. others on a set amount, and others against a multiplier of the applicable minimum wage. In the same way, each state's program is a little bit different in the types of extended paid leave they provide. All states provide extended paid leave for care of and bonding with a new child, whether by birth, adoption, or placement in foster care. They provide extended paid leave for care of a family member with a serious health condition, although I will note family members defined differently in each, and to care for the employee's own serious health condition or disability. California, as of 2021, New York, Washington, Massachusetts, and Connecticut have provisions providing extended paid leave related to a qualifying exigency for a military family member. Massachusetts adds to qualifying extended paid leave a leave to care for a qualified service member. New Jersey and Oregon's programs provide extended paid leave related to certain reasons such as sexual assault, domestic violence, harassment, or stalking. Finally, Connecticut's extended paid leave program provides benefits for serving as an organ or bone marrow donor. Most states have an extended paid leave cap, which caps the total number of weeks that can be used by an employee, even though the sum of the different entitlements could be more than that cap. These caps range from 8 weeks in the District of Columbia to 12 to 14 in Connecticut and Oregon, 16 in Washington, 26 to 30 in New Jersey, Rhode Island, and New York, all the way up to 52 weeks for an employee's own disability in California. As you can see, each state program is a little bit different. Another issue with these extended paid leave programs that I'd like to highlight is the interaction of wage replacement benefits with other paid leave, such as disability, paid family leave, workers' compensation, and employer-provided paid leave, such as vacation. Typically, employers are allowed to require employees to use paid leave benefits during the waiting period prior to receiving wage replacement benefits during an extended paid leave. This is similar to the employer's ability to require the use of paid leave benefits during an otherwise unpaid FMLA leave. Treatment differs, however, once an employee is receiving wage replacement benefits that provide pay at a lower rate than the employee's normal compensation. For example, some state programs provide for payment of a percentage of employee wages. In that case, can employers require the use of paid leave benefits for the portion of pay not covered by the wage replacement benefits under an extended paid leave? For employees on FMLA leave, the answer is no. The FMLA regulations provide that FMLA leave taken pursuant to a disability plan is not unpaid leave, and as a result, neither the employee nor the employer may require the substitution of paid leave. However, the regulations continue on to state that employers and employees may agree, if state law permits, to have paid leave supplement disability plan benefits. For Washington employees, this issue was recently addressed by amendment. In April 2019, the Washington Paid Family and Medical Leave Act was amended to allow employees to elect to use employer-provided paid leave, such as vacation or sick time, to supplement wage replacement benefits from a state program, up to 100% of wages. Washington employers cannot, however, require the employee to do so. This can lead to what we generally refer to as leave stacking, an employee's ability to prolong extended paid leave through use of employer-provided paid leave benefits, such as vacation. New York law, as another example, provides that family leave benefits will not be paid when the employee is receiving total disability benefits or, quote, during periods when the employee is collecting sick pay or paid time off from the employer. The goal of this webinar is not to address these interaction issues under each state's program, but Leslie and I wanted to highlight that this is an area in which state programs differ. Leslie and I have addressed several compliance challenges thus far. Now we would like to transition to strategies for employers to comply with these laws and ordinances. For our multi-jurisdictional employers, one of the primary questions is whether you desire to provide different paid leave benefits to employees in different jurisdictions. First, this answer is informed by a variety of practical considerations. First, where do the majority of your employees perform their work? If the majority are already covered by paid leave laws or ordinances, it may not be too costly to have a uniform policy for all employees that meets the minimum requirements of the law or ordinance. Conversely, if most are not covered, it may be advantageous to have exceptions for small locations that are covered by ordinances. Second, are the employees who are not currently covered working in jurisdictions that are likely to follow the lead of other jurisdictions and enact paid sick leave requirements? If so, consider getting ahead of those jurisdictions with a uniform policy. Third, do you have the capacity to manage different administrative requirements for employees based on their location? If so, is it cost effective for you to devote the resources to managing different paid sick leave policies in different jurisdictions? Finally, will different paid sick leave policies in different jurisdictions result in frustration or confusion among your employees? If employees in different jurisdictions communicate regularly with one another and perform similar work, you may receive questions as to why they are treated differently in terms of paid sick leave benefits. If you choose to treat them differently, be prepared to answer those questions and provide your supervisors with appropriate responses to those questions as well. So let's get down to some strategies. First, identify states that have preemption laws regarding local regulation. As to preemption, there are two significant ways in which this can occur. First, a state can pass a state paid sick time law, which expressly preempts local jurisdictions from enacting paid sick time laws. Good examples here: New Jersey, Maryland, Oregon, and Rhode Island. Maine will join that list on January 1, 2020, when its paid leave law takes effect. The other way in which preemption can be a factor is in states that prohibit local jurisdictions from adopting paid sick leave ordinances even without a state law requiring paid sick leave. There are 19 states with this type of preemption. Leslie, what additional strategies do you have?
To repeat, this area of the law is evolving daily. We emphasize today that many of the current ordinances and laws have conflicting provisions and often fail to address critical issues. Whether it is an amendment to the ordinance or law or an update in the administrative guidance, we expect more changes and interpretations to be issued. Now is the time to create a plan for monitoring updates. Identify those responsible for timely implementing any changes, whether legal counsel, human resources, or other stakeholders. Determine who has ownership of this task and what resources will be used to track any updates. Also, identify who will be responsible for the details of compliance, assuring that employees are provided with the correct amount of sick leave based upon hours worked, what resources will be used to ensure compliance with the record-keeping and notice provisions. Is it advisable to front-load the maximum amount of paid time to avoid carryover issues? Is it advisable to combine all types of leave in one bucket? And if so, does the particular ordinance allow a bucket of paid leave, and under what circumstances? These are all issues that must be evaluated. A reminder of what Amber said early on, do not assume that existing paid leave laws comply with state and local legislation just because you give more generous accrual benefits. Even those clients in a single state should be aware of all potential applicable laws. Is there a state law, a city ordinance, a county ordinance? Remember that all may apply. Study all applicable laws and list the key features side by side to highlight the commonalities and differences. Be sure to answer the key questions for each law. Who are eligible employees? How is paid time accrued? When can paid time be used? Can annual leave accrual be capped? Is there a minimum employment period before an employee may use benefits? How is carryover handled? How is a family member defined? What are the qualifying reasons for use of leave? How does the paid time law interact with existing sick leave plans? What are the workplace posting and individual notice requirements? What are the retention requirements? What are employees' obligations to provide advance notice? What are the limits on an employer's ability to confirm proper use of leave? What time is accrued upon rehire, if any? Many questions, I know. In the end, bolstered with knowledge of the intricacies of the law, employers are presented with an important challenge. While complying with the various legal requirements, in developing the details of your policy, be true to your business goals and to your corporate culture. No doubt, this is a thoughtful, deliberate, time-consuming, but extremely important exercise in achieving compliance.
Leslie and I want to thank you for joining us for the second webinar in Bracewell's 3-webinar series this week. We want to invite you to tomorrow's webinar on a topic of significant interest and fast-paced change by our partner Bob Nichols, who will discuss drug testing, marijuana, and CBD laws and trends. Thank you again for joining us today.